If you have a minor named as a beneficiary for any type of financial account, a bank account, checking, savings, a CD, investments, retirement, life insurance policies, you need to listen to this video. This video today is for you. I'm going to explain to you why you should not name a minor as a beneficiary. Now, this video is going to be specific to Washington State. I'm Darcel Lobo. I own Dow Law Firm. I'm an attorney, and I am only licensed in Washington. So today we're going to talk about in Washington State, if you are a Washington State resident, why you should not have a minor named as a beneficiary. The short answer of it is that under state law, a minor is not competent to inherit anything. So a lot of times these financial companies, they'll let you name a minor. They have no problem with it. But let me tell you about what happens if you do that and you passed away. What's going to happen is that because the person is a minor, the child or grandchild, whoever you've named, because they're a minor, the court's going to get involved. The court is going to have to appoint a guardian for that minor to control those funds. There's going to be limitations on how those funds can be invested, and then the funds are going to be released to that minor when they turn 18. For most of my clients, that's not what they want, and it's probably not what you want. So let's talk about what you should do instead. What you need to do instead is have an estate plan. So if you don't have a will, you don't have a trust, we need to start there. And in doing so, we're going to talk about providing for those minors. For most clients, myself included, I have children as well who are minors. They are not receiving their inheritance at age 18. I have just seen too many 18-year-olds blow through their inheritance, just to be quite frank with you. And so if you want to do so, and I've had a number of clients over the years who have said, Darcel, I really want to leave this to them at age 18. And as long as you are making that informed decision, great, it is your choice. But usually when we talk about it and think about it, we don't want to leave just a large lump sum at age 18. So what do we do instead? We're usually looking at either setting up a custodial account in your will or trust, or a trust for minors. And whether we do one or the other really depends on what level of detail and control you want to have over those funds. So for a custodial account, that's the easiest, that's the simplest. You indicate that those funds are going to be held in the custodial account until they reach a certain age, at least age 18 up to age 25. The custodial account does not go past age 25. If you want to provide for distribution after age 25, then we're doing a trust for the minor child. So sometimes clients want to break the distribution or the inheritance for the child into halves or into thirds. So maybe you want to do half at age 18 and the other half at age 22. Or maybe you want to break it into thirds. You want to do a third at 25, a third at 30, and the last third at 35. I personally like that distribution schedule of ages 25, 30, and 35. And you might be thinking, well, what if they need the money sooner? What if they need money for college? What if they have healthcare needs? No problem, we have you covered. So with that trust for minors, where we're doing ages 25, 30, and 35, where they're getting a third at each distribution, before those ages and in between, funds can be used to care for them. So to pay for education, their healthcare needs, their overall well-being. So you're naming someone to be in charge of those funds. So not the child, someone else that you trust to manage those funds and to pay for those expenses as they come up. Again, if the kid goes to college, to pay for what's needed for, tuition and for books and lab fees, things like that. If the child needs a car, helping them with buying a car with the funds from the trust. But there's no lump sums being given to that child outright until they reach those ages. So again, in this example, at age 25, they're going to get a check for 1/3 of the balance in that account. Then at age 30, they're going to get another check. And then at age 35, they're going to get that last check. But again, in between those ages, before those ages, if funds are needed, for, again, their well-being, their education, healthcare, things like that. Those expenses can be paid by the trust, and the child gets a lump sum check at the ages you've specified. Now, you don't have to do ages 25, 30, and 35. When I have clients come to me who aren't sure what ages they want to leave the inheritance at, I recommend that. But again, if you want to do it in half, and again, age 18 and age 25, if you want to do age 25 and age 30, if you want to do it beyond age 35 and go to age 40, age 45, we can, but there has to be a date and time in which the funds are distributed to the child. There has to be an endpoint. It can't go on indefinitely. So if you, again, are providing for minors as beneficiaries and you're in Washington State and you're realizing like, oh, maybe I haven't quite thought this through, maybe I do need to look at an estate plan and kind of make some changes, give our office a call, visit us online. I'll have our contact information below, and we'd be happy to see if we can help you. All right, thank you and have a great day.